Good afternoon, everyone. I'm Namita Wahi. I'm a senior fellow at the Center for Policy Research and director of the Land Rights Initiative. And on behalf of the Land Rights Initiative and the Center, I'm delighted to welcome all of you to the seventh talk in the Land Rights Initiative Legal History Speaker Series. The Legal History Speaker Series is one of a series of events that we have launched in order to celebrate the 10th anniversary of the Land Rights Initiative, which we celebrated last month on November 11th. And I want to thank all of you who have been, a part of Land Rights Initiative's journey over the last 10 years and who've also been part of this series over the last several months. As the year closes, this will be the last talk in the legal history series for this year, but of course, we'll be back next year and continue the series with that. So why did we decide to organize a series on legal history as part of the 10th anniversary celebrations? The reason behind this was because all of our work at the Land Rights Initiative, whether it is on land acquisition, land rights of scheduled tribes and scheduled areas, property rights, water rights, health rights, and our flagship 1000 Land Laws project, which is available online at landlawsofindia.org. In all of our work, our methodology has been to use legal history in order to understand the policy questions of the present. And that is because we found in our work that despite a significant, rupture at the time of the adoption of the Constitution, a significant rupture that happened as we moved from colonial to post-colonial rule with the adoption of the Constitution in 1950. There are many significant continuities between the colonial and the post-colonial past. And to give you an example from the Land Laws website, so we have about 500 land laws on the website, and I invite you to check out the website because it is the first interactive exploratory archive of all land laws in India, central land laws and laws from 8 states. And the 500 land laws that we have on the website, along with their summaries and so on, of them, about 150 laws are colonial laws and 350 are post-colonial laws. So the fact of the matter is that as many as 150 colonial laws exist in the space of land laws, which are still governing our lives. So we really need to understand the continuities. At the same time, the adoption of the Constitution did mark a significant rupture. It is the moment when all Indians went overnight from being subjects to citizens. We talked about this earlier in our talks as well. And the Constitution guaranteed in Part 3 certain fundamental rights. We talked about the fundamental right to property in our last talk. We talked about the right to free speech in the third talk in the series. So we have these rights that were guaranteed, the rights to life, liberty, and property, right? And at the same time, the Constitution also contained in Part 4 a chapter on directive principles of state policy. And again, we referred to the directive principles of state policy in our last talk because one of the directive principles of state policy is to ensure that in Article 39, that the material resources of the community must be so distributed as best to subserve the common good, and that the state must act in order to prevent concentration of economic power. And we talked about that in the context of property rights in the last talk. And we talked also about the recent Supreme Court judgment in the case of Property Owners Association versus Union of India. But the concentration of economic power, we've talked about that in the context of property and land laws and land rights. But we also find concentration of economic power with corporations, with big entities, which may not necessarily be corporations. There could be other forms of economic entities that exist, partnerships and so on. And in many ways, this directive in the Constitution to ensure concentration of economic wealth was essentially to ensure that power is distributed. In other words, we become citizens, truly sovereign citizens. And here I refer to Maurice Cohen's classic essay on property and sovereignty, where he talks about how, a sovereign government controls the lives of the people, but he explains how property owners, and especially in corporations, but also other property owners. So for example, a landlord vis-a-vis a tenant and corporate control, that, in the absence of protections, like labor protections and so on, the property owner can actually control the lives of the people that are working for them. And of course, that was already happening prior to democracy, when slavery and so on, where basically people, and feudalism, right? People control the lives of people who were working for them. And that was supposed to shift post democracy, post the adoption of the constitution, and so on. But the real and so it was in pursuance of that that we adopted the directive principles, and it was in pursuance of the directive principles that we have passed a series of legislation, starting from the Monopolies and Restrictive Trade Practices Act to the Competition Act in 2002. And we really need to understand this, because not just economic power in terms of like controlling what we can earn and what we can work with, but even our rights to free speech and so on, which are our right protections against the government. But because of the fact that, the rise of big tech, we find that all of our free speech rights are also in a way subject to the regulation of these technology companies, right? So we really need to understand the scope of power between the government and these companies, and to understand how the current laws that we have, how well they are able to regulate and redistribute power, really to pursue the directive in Article 39B, which is to ensure that all the material resources are best distributed to subserve the common good. So it is in that context, it is my great pleasure and privilege to welcome Parthsarathi Jha, who is a partner in the Competition Law and Policy and International Trade and Customs Practices at Economic Law Practices, a leading law firm in India. Parth, as I have known him for the past decade, advises clients on a broad range of matters, including merger control, antitrust issues, trade remedy investigations, including anti-dumping and safeguards, and customs disputes. So, as I understand it, there are two or three broad areas of practice in which Parth works. One is competition law, where he advises clients on issues relating to regulatory compliance, investigations, and merger filings. And he has represented many clients in high-profile cases related to anti-competitive practices and market dominance. The second area of his expertise is trade law, where he has represented the government of India in several disputes at the WTO, the World Trade Organization, including DS 150, which is India, certain measures relating to solar cells and solar modules, and another case which was concerning measures concerning sugar and sugarcane. Parth specializes in anti-dumping safeguards and trade policy compliance, and advises clients across sectors like chemicals, pharmaceuticals, and steel on government investigations and cross-border trade issues. And finally, in his third area of work is mergers and acquisitions, where he has done extensive advising on corporate transactions, due diligence, and joint ventures across diverse industries. This was also my earlier life, mergers and acquisitions, when I was working in New York. Parth has been recognized as an up-and-coming lawyer for trade in Chambers Asia Pacific and in ALB's India Rising Stars of 2022. He's licensed to practice law in both India and New York in the United States. He holds an LLM from Harvard Law School and BLLB degrees from the Hidayatullah National Law University, Raipur. So without further ado, welcome, Parth. Really looking forward to your talk, and I hand over the floor to you.
Hope this is working. Yeah. So first of all, thank you, Namita, for having me here. And it's great to see the journey of Land Rights Initiative, and congratulations on the mammoth work which you have done on land rights and the completion of 10 years of your project. For the first time when you requested me for this talk, I was a little bit intrigued that how do I fit competition law into this? But you have very beautifully articulated the key issue, which is being currently debated across the globe, which you put in terms of sovereignty, the relationship between state and the corporations and citizens, and that actually leads to the whole question about what should be or what ought to be the goal of competition laws and antitrust laws. What I'm going to do is that instead of responding to that question right now, because that question is something which is being debated as we speak, I'm going to lay down a substrata for this question so that audience can understand what we're talking about, what's the underlying undercurrents which have happened over the last several years that this question has popped up. And in doing so, what I'll do is that I'll also trace the key issue, which is the legal history talk. I'm going to trace the whole history of the competition law from a political economic angle, so political economy of this whole stuff. So this is a big task. I have 35 to 40 minutes. And therefore, what I'm going to do is that I'm going to be fast in some areas, and I'm going to slow down in some areas. But please feel free to ask questions at the end of the presentation, and I'll be happy to take those. And before I do that, a few qualifications. Well, I practice competition law with economic laws practice, and in that process, I do advise many clients, and some of my clients are big tech clients. Today, we will discuss big tech, so therefore, some of my views may seem to appear that they are favoring big tech, or they may be ideologically biased, and I'm happy to take that criticism, but that disclaimer was necessary at the beginning. I also wanted to disclaim that this talk is not sponsored by any entity. No, none of my clients are sponsoring this talk. So the stuff which I'm going to speak about and the views which I'm going to throw, there is no quid pro quo consideration behind that. So those are my own views. And none of this, all of this are my individual views. They do not apply to any of my clients or my organization, so to say. With that caveat, let me begin with my presentation.
There is no consideration from us except for coffee, which is all we can provide as speakers. So making that clear.
Yes. You want any clarificatory questions at all, or none at all?
No, I think we'll have the talk first and then we can take questions. Yeah, not right now.
Will this presentation be available? So that, or should I be taking notes?
I mean, you can take notes and we can talk about sending it to you later.
Okay.
But let's start, please. Let the speaker speak.
Thank you. So I'm going to touch upon these areas, which is early origins of competition law, prior to 1947, then the 1950, the adoption of constitution, then the first few years of the planned economy, then the whole MRTP Act which came into existence, subsequent reform in 1991, the Competition Act enactment, and then subsequent to Competition Act enactment, what has been the journey of the CCI in the last 14-15 years, and subsequently where we are today when we talk about big tech. So many ideas and themes will be touched upon. Let me go quickly. So first take, when we talk about competition law, what is that which we talk about? So it's ironic that when I'm talking about India's history with competition law, tryst with competition law, some of the statements which you'll see on the screen are not from any Indian scholar or Indian policymaker, so to say. And the reason being is that one, there is a dearth of debate on the core issue around what should be the goals of competition law in India, to the extent that has happened already outside India. And two, that what has happened outside India predates the developments in India. So to that extent, it's important to understand what has happened outside India also. And at relevant point in time during this presentation, I'll come to that. But quickly speaking about what do we mean by competition law? So as we know, in markets, firms operate, and there is this relationship between firms and consumers, or producers or suppliers and consumers. And that relationship is lopsided in the sense that consumers are always, or in most cases, at the mercy of the producers or suppliers, right? And this lopsided relationship, if left for completely unguided, unregulated situation, then in most cases, it will so happen that the players in the market, which are the producers, suppliers, whatever you want to name them, they would always have a sort of I would say, higher bargaining position vis-a-vis consumers. So in order to balance that position, right, legislations, I mean, policymakers come with various tools. One of the tools is competition law. I mean, that's not the only tool. There are other tools in which you try and gap that asymmetry, but competition law is one of the tools. Essentially, what it does, it says that, well, you can't do anything which is anti-competitive. For example, you can't cartelize and fix prices, because if producers fix prices, which means that they will be raising prices at the cost of consumer, right? So consumer will be paying a lot more prices, and the entire consumer surplus, which you call in economics, will shift to few handful of producers, and that's how they will benefit by extracting from consumers. And that is something which is obviously, by very common sense, should not be allowed, right? So competition law tries to regulate markets so that you don't have, or at least to reduce anti-competitive practices in the markets. Cartel was just one example. One player may be very big, it can be dominant, it can be so dominant that it can do anything what it likes in a market. So it can engage in unilateral conduct, which can harm competition, which can harm consumers. So competition law regulates that. Now, what you see on the slide is essentially the two thoughts which have emerged in last 100 years, I would say. which one is that what should be the goal of competition law? And there is a thought which says competition law should be only concerned about what we call consumer welfare standard, or some at least there is a community which calls it consumer welfare standard, which essentially they mean that it should be concerned with lowest prices for consumers, largest output, and innovation. But there is other thought which says that no, that's not the only goal of competition law. The competition law should also be concerned with the market structure itself, that what is the process of competition, what is the market structure, and therefore it should be also concerned with certain other immeasurable things, which is about inequality, which is about in today's world, perhaps privacy, other harms, democratic values, and all of that. And if I may, I mean, it may be a little bit of a statement, but the journey of antitrust thought outside India and in India perhaps is essentially the interplay between these two opposing thoughts on antitrust. Quickly, I will come to the early origins. So even before, I mean, 1969 was not as such a watershed moment from anti-monopoly law in India. You had some ideas of anti-monopoly law in India even before 1947, and the idea against anti-monopoly, I mean, it saw its roots essentially in the 15th, 16th century in UK, and you had some of these acts at that time which forbid certain forms of anti-monopoly practices, right? And that became part of the common law and also impacted India's own law. For example, you had Indian Contract Act of 1872, where you had Section 27, which essentially prohibited contracts which are in restraint of trade, they were considered to be void. And so pre-1947, there were therefore some ideas on free competition or fairness in the market. That idea was already with us. Then in 1951, we came out with our first industrial policy resolution. That policy resolution talked about how India will plan its economy. So it was a mixed economy, as you know. So there were certain sectors which were left for state, certain sectors were left for where state and private sector will coordinate, and then certain were left for private sector as well. Most importantly, I think there is a slide missing here, but I will just explain that. Most importantly, in 1950, you had the Indian Constitution. Now, Indian Constitution provided for three things at that time. One is right to hold, own, and dispose of property. Second was right to trade, business, and profession. And third, which Namita was explaining, was this Directive Principles, Article 39B, which essentially said that the state will formulate laws, that it's the duty of the state to formulate laws so as to see that there is no concentration of economic power. Now, if you look at, there seems to be a tension between that, right? If you have a right to hold property, if you have a right to trade, which means you would like to carry on your trade as you would like, as you would want, and there should not be any intervention. But these rights were not fully absolute, in the sense that in 1951 you had the First Amendment to the Constitution, where exceptions to 19(1)(g) were provided, where right to trade, profession, etc. was qualified. Right to property was subsequently even deleted as a fundamental right and became just a legal right in the Constitution. Namita has already discussed about these things in detail in our last talk, so I'm not going to that. So idea is that despite a seeming tension, there is a place where both of them can marry, and that is evident from the way the courts have looked at it and the way India's own policy, economic policy, also evolved. So if you look at from 1951 to 1969, there were growing concerns in the licensed Raj, in the planned economy, that certain private sectors were getting enormous amount of power in terms of the concentration of wealth. And various studies were made. So first one, the 1956 industrial resolution, industrial policy, emphasized on the fact that we need to prevent private monopolies, right? Then in 1961, the third five-year plan also emphasized upon that there has to be an even distribution of economic power and recommended various steps to actually achieve that. 1964, Monopolies Committee came out with its report, and it also that found that there was some level of economic concentration already present in the Indian economy. And then in 1965, you had, based on all that happened in past, the government formed this Committee on Monopolies Inquiries Commission. And this commission's report is very detailed one. It goes into product level study and industry level study and family wise study, that what is the level of concentration, right? And if you see at product wise concentration, it found that 100 industries in India were surveyed, and out of that 65 were found to be with high level of concentration. When they look at company wise concentration, out of 1609 companies, they found that 75 big houses were controlling all of these, right? So the Dasgupta committee report came out with the findings that India had by that time already witnessed a very high level of economic concentration, and therefore it recommended certain measures. One of the major legislative measures was that you come out with an anti-monopoly law, and there were many other recommendations as well. Around the same time, Hazari committee report also came out. Hazari committee report also said that biggest business houses were accounting for more than 21% of the total license applications. 28 large industrial houses flourished under the license rule. So again, the findings were pointing towards that economy was economic power was being concentrated in the hands of few. And so came the Dutt committee report around the same time, and all of these actually said about that there was a lot of economic concentration which has already happened in India's first 20 years, when from the time of independence. And it is in this context, and there were other political events which happened, I'm not going to into that, but it is in this context that you had the MRTP Act of 1969, which finally came into force only in 1970. Now, what MRTP Act did, and before I go to MRTP Act, it's not that the idea of monopoly was not there at all. And if you look at some of the earlier discussions of Supreme Court has looked at monopolistic practices, but not from an angle of anti-monopoly law, because there was no anti-monopoly law, but from the angle of individual rights versus public interest. So in some cases, certain acts by a state could have impacted somebody's right to, let's say, free speech, or some individual's right to Article 19(1)(g). And in those cases, after doing a balance between public interest and individual rights, Supreme Court had actually set aside certain laws on the ground that it violates other fundamental rights. Competition issue, but looked at from a constitutional issue. So I just wanted to bring that out before I go to MRTP provisions. Now, MRTP provisions essentially at that time regulated when it came into, as it came in 1970, there were various amendments which happened between 1970 and 1991, but the original act provided for three kinds of provisions. One was prohibiting restrictive trade practices, two was monopolistic trade practices, and third was concentration of economic power. What is more important, which I'll come later on, that if you look at the statement of objects and reasons, even the long title, there was clear focus that they wanted to control this concentration of economic power, which is on the slide. And I'll come to this, why it is important at subsequent part of my speech today. And just on restrictive trade practices and monopolistic trade practices and economic concentration, and all of these, there was an effect test already built even in the MRTP law, and I'll come to that as well subsequently, because there's a lot of talk always around that as if MRTP law was always what big and bad, big is bad, and there was like no effect test. But when it came in the shape it came, the restrictive trade practices were not just defined by act, but it had to have some level of effect which harms the competition in the market by reducing supply, by reducing production, and all of that. It was inbuilt in the definition itself. So was the case with monopolistic trade practices. That what is that which is a monopolistic trade practice? Again, their effect was inbuilt in the definition itself. Some of this were amended subsequently in 1984, but I just wanted to focus on that the MRTP law itself had some sort of dichotomy with the object which it wanted to achieve and the way the regulations were framed. Even the merger control provisions, which were called the concentration of economic power under the MRTP law, had ideas about efficiency, that you look at the factor that whether a proposed merger is likely to increase efficiency or not. And that was one of the factors. So while the act talked about reducing concentration of economic power, but if you look at the language of the law, it was not so much against the reduction of economic power, but it was looking at effect on the competition. So even if you have a concentration of economic power, but if you are not indulging into anti-competitive practices, perhaps act didn't really shun that. That's an important point which I'll come to later on. And then there were discussions about the whole interpretation of how it was, whether it was a rule of reason approach or per se. I'm skipping that, not important right now, and I have limited time. I want to quickly come into the whole analysis and effect of MRTP law, whether it was able to reduce economic concentration or not. There are not many studies. There are some studies. And these studies do not point out to that by 1991, or for that matter by 1999, did India really see a decline in concentration of economic power? Was MRTP Act really effective? There is no study which demonstrates to the fact that it did. There is one study which I am demonstrating here, which demonstrates there was some decline in concentration of economic power. But remember, the state was also withdrawing from industry sector slowly. So public sector was withdrawing, and since public sector was withdrawing, there was some decline in economic concentration just because public sector started withdrawing as well, right? But there is no defined study which demonstrates that MRTP actually resulted into a decrease in concentration. In fact, to the opposite, there are writings around that period, and even in 2008, around 2008-10, when we look at that, the whole MRTP law was practiced in a manner to suit. There was a lot of political patronage and political favoritism, right? So naturally, even if you had a good law, so to say, let's say on paper, if you do not practice in the manner you'd like to practice, then because the more important issue is that the merger control powers were with the central government. Only if central government thinks that they need to inquire into something, they will pass it on to the commission to look at it. In most cases where you had political patronage, either the central government under different regimes will allow the merger or not allow the merger, right? So again, it's important that you may have a good law, but if the enforcement of law is poor, you may end up with same situation, right? Then you have, in 1989, you have the fall of Berlin Wall, the end of Cold War era, and democracy as an idea was engulfing whole of the world. And with that, liberal economic ideas were also, economic liberalism also spreading. And India, the idea also came to India by 1991, and you had the reform agenda, right? So between 1991 to 2000, right, India also becomes party to WTO in 1995. And then there was a WTO Singapore ministerial declaration on trade and competition, the interplay between them. India also started to look at, with the economic liberalization, that perhaps its competition law are archaic, and therefore there may be a need to reform the law and relook at the law. And you had the Raghavan Committee report. With the Raghavan Committee report, you had the new competition law. What is very important is that before I get to what happened in the Raghavan Committee report, what does the new competition law do? The competition law of 2002. The Competition Act of 2002, one, there was no substantive debate in the parliament. We really don't know what the parliament is intended, okay? Two is that it regulated three things. One, it prohibited anti-competitive agreements, like I said, cartels, horizontal agreements, vertical agreements like exclusive supply agreements, tie-in arrangements, refusal to deal agreements based on certain criteria. Two, it prohibited abuse of dominance, not dominance, abuse of dominance. You may be dominant, but only if you abuse your dominant, then you are crossing the red line. Three, it regulated mergers and acquisitions. So certain mergers, if they meet certain definitional thresholds, they need to go to the commission before they are consummated or given effect to. Only if commission think that it is good to go, they will give you a go ahead, and then you can do that. And there are a few other things, significant penalty powers and all of that. You had the CCI established. Now, forget about the initial challenges, constitutional challenges to this, but let's look at this slide. Continuity or departure in terms of, did Competition Act really was a complete, a new breakaway from its past? And if you look at, it was in some senses, but it was not in some other senses. If you look at the MRTP's long title, right, it was very clearly targeted towards concentration of economic power. But if you look at Competition Act, you will not find a mention about concentration of economic power. Not even in the statements of objects and reasons when the act came out. Not even in the Raghavan Committee report, which actually came out. Raghavan Committee report refers to 39B only once in context of referring to MRTP law, not in the context of what they are designing or what the new law they are designing. They're not talking about that. And this difference is very, very significant in my opinion. Now, if you look at the preamble of the Competition Act, it talks about to prevent practices having adverse effect on competition. It doesn't matter whether you're big or bad. Your practice should have an effect on competition, adverse effect on competition, right? That is one. And then, of course, to promote and sustain competition in the markets, somebody will argue that this is about the structure of the market. Then, of course, to protect the interest of consumers. But there is no mention about concentration of economic power in the Competition Act. Now, even if you look at the merger control provisions, right, the way merger control provisions are to be assessed in the Competition Act and MRTP, I'm sorry, the slide might be smaller, the text, but you look at this, under the Competition Act, the criteria on which you assess a merger control, there is no mention about distribution of material resources or concentration of economic power. But on the contrary, if you go to the MRTP law, you'll find one of the criteria for which will be taken into account to decide whether merger should be allowed or not, was to regulate the control of the material resources of the community to the subserve the common good. And this is again a conspicuous absence in the new Competition Act. But at the same time, if you look at the MRTP law obviously very, very clearly talked about efficiency. And efficiency, if you look at to achieve the production, supply, and distribution by most efficient and economic means, right? And that efficiency as a language is missing in the Competition Act if you look at the factors under which merger control is. So it's kind of a very strange scenario. I mean, nobody has looked at it from this angle. I mean, I haven't come across any writings, but this is a bit strange there. But again, I wanted to point out that there is some convergence and some divergence. And the biggest divergence for me is that the Competition Act did not very expressly identified the idea that it is somehow trying to promote the goals under Article 39. It may be doing it indirectly, but the statute language is not there. Now, before I come there, on a few other aspects, which is about anti-competitive agreements and abuse of dominance, there is some level of convergence. I told you there is some convergence with MRTP law as well. If you look at the anti-competitive, not every anti-competitive agreement is bad. Ultimately, you'll have to demonstrate under the Indian Competition Act today that this is likely to lead or cause an adverse effect on competition, what we call AEC. Even under the abuse of dominance provisions, there was this theory that for abuse of dominance, you don't need to demonstrate effects. And if you just do a conduct, because the way language has been drafted in statute, if you're dominant and you engage a conduct, let's say unfair trade practice or a discriminatory trade practice, you are abusing your dominant position. That theory has been debunked by Compat very recently in one of the cases where they say no, effect test is inbuilt in Section 4 and you'll have to demonstrate effect there as well. So harm to competition has to be demonstrated. And to that extent, I think there is convergence between MRTP law and Competition Act. Now, I will go to the trends of the CCI enforcement. But before I do that trend analysis, it's very important to introduce one element, which I talked about at the very beginning, which was happening parallelly outside India, which India did not witness. And it's important. Until 1960s, around that time, because look at US is the biggest, I would say, proponent of the antitrust law, with 1890 Sherman Act being the first sort of codified antitrust law in the world. Until around 1960, the United States' outlook towards antitrust law was more towards market structure. It was more individual rights based. So if an individual's right to trade is offended or somehow he's being excluded from the market, that was a concern for competition law. And by 1970s, a new school started coming out, which is Chicago School, neoliberal school of economics. He said this is wrong. All you should look at is that if there is a conduct, whether this conduct is actually affecting market in an adverse manner from a consumer price point of view, whether it is increasing price or lowering price, whether it is increasing output or lowering output. Merely because the corporation or the enterprise is big, you can't punish them. You'll have to look at what is the effect on the consumer. In that process, if few smaller players go away from the market, you shouldn't be concerned about that. And that debate happened there, right? Now, if you look at our own law, there was no debate around this, what should be the goals of the competition law. But your preamble says that it is to prevent adverse effect on competition in the market. And therefore, one would think that perhaps it was more geared towards looking at effect on the competition in the market, not as such effect on individuals or individual, let's say, rivals or competitors. Now, there are a couple of cases which went to the Supreme Court in initial years. The issue of what should be the goal of the antitrust law was not posed before this. But as you know, our Supreme Court, lots of obiter dicta, many things come. The very first case, and I wrote about this back in 2010, which was about CCI versus SAIL, issue was not about what is the goal of the antitrust law. The issue was very distinct administrative issue, right? I'm not going to get into that. It will elongate our discussion. But as the Supreme Court passed its final order, it made certain observations. And it observed that the goal of the Competition Act seems to be to promote economic efficiency and allocative efficiency. And allocative efficiency is a very important element of Chicago School when they talk about consumer welfare standard. What they mean essentially that you should only look at whether resources are being allocated efficiently or not, because firm as a rational animal of the market will always try to allocate resources in most efficient manner so that it can produce highest amount of goods at the lowest cost, and so that it can again maximum profit, right? So it very clearly says that the goal of the competition law is to enhance economic efficiency and allocative efficiency, and CCI was established to prevent adverse effect on competition and protect consumer, right? No discussions on whether it should be Harvard School, Chicago School. Supreme Court directly in an obiter said that the goal is to enhance economic efficiency. This line was also followed in Excel Crop, but here is a slight distinction in Coal India. Coal India was a slightly different case. It was a case against Coal India. Coal India tried to say that, look, I am not state. Sorry, I'm state. I should be exempt. It's sovereign function, all of that. Supreme Court didn't agree with that. It said that if anti-monopoly is prohibited for private parties, I don't know why anti-monopoly will not be prohibited for a state. While in this discussion, what happened is that they also came out with this Nationalization Act, because they were nationalized under the Nationalization Act. And they said that the whole purpose for our creation is 39B, which is to see that material resources of the community are served for the common good, right? And therefore, you should look at me differently. Competition Act Section 42 shouldn't apply to me. And the Supreme Court says, it's not a so good written judgment, but the Supreme Court says that the idea of common good as enshrined in 39B is itself a good which Competition Act promotes. In effect, not in so many words, right? So all I'm trying to say is that somewhere in Coal India, this idea of common good and distribution of material resources has to be not concentrated with someone. I mean, if you just look at it from a broader perspective, somebody can argue that somehow that itself is a good which Competition Act is promoting, because Competition Act is notwithstanding any other law, and Parliament has wisdom that it has seen all other law when it passed Competition Act, right? And let's look at the trends of CCI trends itself. Can we discern something? And my own conclusion is that it's very difficult to discern any particular school of thought from CCI's own trends. If you look at some of the initial year cases, CCI's focus was in some ways consumer centric. So there were cases against builders, developers, and buyers association, which on the face of it looked like a consumer centric case, but CCI looked at those, entertained those, found in some cases these developers as abusing dominant position. They defined markets narrowly, sometimes Gurugram, sometimes other markets, and they found them to be abusing dominant position. Then you had cases for example, if you look at the Hiranandani case, here again there was exclusive tie-up between a stem cell provider and the hospital. They didn't allow them. I'm not going into facts because we have limited time, but again, it was to serve the consumer purpose. But at the same time, if you look at some of the pharma cases around the same time, these pharma cases, some ad hoc, some individual stockist will come and complain that I'm not getting license for selling drugs, and therefore there is an anti-competitive practice here. CCI has entailed a bunch of those cases without looking at the fact that whether there has been any lesser supply of medicines in any particular area, or whether there has been an increase in prices of medicines. No analysis at all. But just because merely an individual came and said that I am not getting a license to deal in these medicinal drugs or medicines for that matter, there is a anti-competitive practice, and CCI entertains those in favor, and that's where it seems to be closer to Harvard School. So there is a mixed trend. I'll skip this slide. Maybe this will come at in the Q&A session. But let's look at its enforcement trend when it comes to big tech. If you look at CCI's enforcement trend prior to 2017-18, I would say most of the cases were closed at the prima facie stage. What do I mean? If you file an information before CCI first at a prima facie level looks at whether there is a case for investigation or not. If it finds that there is a case for investigation, it directs the DG to investigate and come out with a wholesome report, and then CCI will look at that. But if it finds that, well, there is no merit, it will close at the prima facie level and pass an order closing the case. Most cases until around 2018 were closed at the prima facie stage, saying that there is no case on a variety of issues. In fact, if you look at, I can't get into the details of all of these cases, but I'll just take one case on Ola Uber cases, a bunch of Ola Uber cases really. What the traditional radio taxi guys like Mega, I mean, you remember Meru, Mega, all those cabs, their complaint was that I'm just not able to compete in this market because they have come and all the cab drivers are now into their market. They're giving huge amount of discounts, better pricing, and I'm not able to compete. CCI is concerned. I mean, CCI, in some cases, they tried to get it in abuse of dominance. Some cases, they got it into anti-competitive practices. The challenge is that you need to demonstrate dominance before you can get to abuse of dominance. And in most cases, they fail because, demonstrating dominance, you'll have to define relevant market share, and other countervailing factors, and all of that. It becomes difficult. Be that as it may, there's a CCI said in some cases that, what has stopped you from getting the venture funding which you are alleging they have got? Is there, I mean, essentially what CCA was saying, that is there a, is there the capital market, is that a distorted capital market? Why can't you go and get the venture funding? Why can't you provide the same? I mean, the whole idea of competition in CCI's view was to come out with better technological products, and you can't really say because merely because they're coming out of better technology in app, they are harming you. I am not entertaining you. That was the line and thought in the initial years until 2019.
What's the composition of the Competition Commission of India? Who are the members?
Yeah, that's a good question. And this happened, the 2007, I mean, Brahmadat case was also about that. Mostly, right, it has been a bureaucratic centric commission in the sense that it will be either retired IS officers or IRS officers. There have been times when you had also, at least there was a period of 3-4 years when you had a judge from the High Court. But otherwise, mostly it's bureaucratic. Only very recently, and this is the present commission which I'm talking about, which is currently composed of bureaucrats plus one private lawyer, right? So a private lawyer who gets a commission membership, right? But mostly it's bureaucratic. If your question was geared that who are these people, so mostly they are retired bureaucrats or bureaucrats who have not yet retired but they have taken a position and commission, right? So if you look at the trend before 2018, mostly what happened is that these cases were closed at the threshold level. But around the same time, again, diverse from CCI and will go outside India for a moment. At the same time, something else was cooking up in the United States. And 2000 onwards, when you started looking at the whole new revolution, right, the tech revolution and the digital industry is coming up, a new idea emerged, what we call now called neo-Brandeisianism. Original root was Brandeisianism, which said that the way antitrust has been looked at by the United States courts, economists, and all of that, they have made a huge mistake. It has went into under-regulation. They have not regulated competition, and they have not enforced competition vigorously, and therefore there is a need to relook at our own enforcement. And this idea came with the rise of the big tech, because now you had suddenly the big tech of the world, whether it is Microsoft's or Facebook's or Netflix or Google, all of them, they started lumping them together, saying that with the rise of the big tech, they have got huge amount of power, and with that power, there are other areas of areas of our lives as a citizen in any jurisdiction for that matter, which is being threatened, and antitrust enforcement should be much more vigorous. And Lina Khan, one of the greatest proponents of this Brandeisian school, she came out with her paper, Amazon's Antitrust Paradox, which is perhaps one of the boldest paper from the neo-Brandeisian school, which argued that how Amazon has been allowed through a law enforcement regulation, how it has been allowed to amass a lot of economic power, and there is a need to relook at that. And there is this whole distinction between Chicago and neo-Brandeisian school. I'm not going to read it through, but if you just look at, Chicago school looks at market power as it's not inherently harmful. Only it becomes problematic when you get into higher prices or reduce output. But the Brandeisian school says that no, market power is inherently harmful, because the fact that you have a market power, there is a lot of danger, right? So each of the parameters that we look at, you'll see there is a distinction between Chicago school and Brandeisian school. And that impacted a lot of things. In Europe, you suddenly had this idea that big tech needs to be regulated, and you had something called Digital Markets Act. What Digital Markets Act does, I'll come to separately, which is very close to our own DCB, Digital Competition Bill. But it essentially does that. It identifies a bunch of people and says that you guys are very big, and if you engage into certain conducts, you can't do that. That's prohibited. You can't do certain things. So it identifies few people and tells them you cannot do certain things. They call them gatekeepers, right? That happened in the European Union. Around the same time, there was this, again, we're talking about the political economy. There was a big, push against the Amazons and Flipkarts of the world by, Kirana stores and all of that, Confederation of CIT. They said that, they are taking a lot of business away from offline market, and there has to be a relook into this, right? Commission started with a study on e-commerce in 2020. Now, look at what happened between 2018 to 2021 and subsequently until 2024. You'll see the initial cases where Commission was shutting down on the threshold, you started investigating more and more cases against big tech, often either driven by, arguably, there is no proof to this because nobody has looked at Commission papers, but arguably what's happening outside India. So in Europe, You would have a case against Google smartphones. A commission will come out with a, let's say, finding that they have found Google to be abusive in India. On that basis, there will be a case which will be filed and CCI will look at that, right? Similarly, some of the cases which were previously closed against WhatsApp and all, suddenly that those cases, I mean, new cases came up and CCI entertained that, and you'll see where I come to the CCI's meta decision recently. I mean, I'm trying to generalize it in that it's not so generalized. You have the nuances, the facts of each of the case, but all I'm trying to say is that if you look at post 2018-19, we'll see a change in CCI's outlook where they are now regulating big tech, right?
But even with the change, if I look at the slide, most of them are still closed.
No, not most of them are closed. If you come to, if you see, some of them were closed, but there were some cases which started reopening. If you come to the next slide, you'll see that there are many cases which have been started. Look, many cases have been closed not because an ideological position, merely because you had a bad case to begin with, right? So if you look at one of the cases, if you look at on the extreme right, this is Bhagelkar Kumar versus Google. The allegation in this case was that you are integrating Gmeet with Gmail. So if you open your Gmail, you will also find Google Meet there, and this integration is bad. Now, why is this bad? There was no case at all. Like, you don't want to use Gmeet, you don't want to use Gmeet. Merely because you're using Gmail doesn't mean that you'll have to necessarily use Gmeet as well, right? So some of the cases were also just a bad case to bring before the CCI. But you'll see that there is a trend where they have started looking at the cases. Same OYO, Ola, cases against previously OYO, which were not entertained on different facts. Cases against OYO MT were looked at. So I'm not saying that there is like a lot of cases which have gone against them, but you'll see the change that that's happening where CCI is looking at more and more cases. So then, like I said, I was talking about the Google cases in 2022. Then you had this smartphone case against Google. Then you had this Play Store case against Google. In both these cases, Google was found to be abusing its dominant position. You also had cases against McMyTrip and OYO. There again, they were found to be, violating their dominant position and also anti-competitive practices. Now, subsequent to this, there have been new cases which have been launched. So Digital Newspaper Publishers and Association has filed a case against Google. That case is ongoing. There is a case by National Restaurant Association of India against Zomato and Swiggy. That case is ongoing. You already have a case against Flipkart and Amazon that is ongoing. You might be reading the newspapers right now. The reports had come out. You also had a case against Apple. Again, that case is ongoing. We don't know the outcome of these cases, but these cases are different stages right now within the commission. Some with the commission DG report out. In some cases, the investigation is ongoing. But the investigations are going on. So therefore, at one way, we look at that most cases are closed, but there are so many cases which are also ongoing at this point in time. So around the same time, what happened? So I'll come to the meta decision, but before I come to the meta decision, what happened also in between was that there was a parliamentary standing committee in 2022 which talked about anti-competitive practices by big tech companies, and based on this report, again a committee was set up, and that committee looked at that do we really need a new competition law, and some call it's not a competition law, some people call it as industrial policy, to look at the practices of big tech. And as a consequence of that, the Committee on Digital Competition came out with a report and a bill which is called Digital Competition Bill. And what they do is similar to DMA, European Digital Markets Act. They identify certain people as systematically significant digital enterprises, SSD, okay? And they identify certain core services, that these are the services if you are engaged in that. And if you meet certain threshold, not in the product revenue, if you just meet certain threshold by your asset or turnover or user base, depending upon what you're talking about, you become a SSD, systematically significant digital enterprises. And if you are an SSD, there are certain things which you cannot do. And no questions asked. You can't even defend yourself or provide an objective justification that why you are engaging in this conduct, or whether this conduct is harming the competition or not, whether it is harmful at all or not. If it is harming sub-segment, well, it is providing benefits to any other segment or not. Can I do some balancing between the pro-competitive effect and anti-competitive effects? No questions asked. You can't do certain things at all. For example, you can't self-preference. So for example, if you're Amazon and if you're on a platform, you can't list your own products above other products, right? So you can't self-preference. You can't restrict third-party service providers to coming on your platform. You can't tie and bundle some of your products together. You can't share data which you take from your users or other business users or end users, let's say people like us. You can't use it for across company purposes where you are using data from one side and utilizing it for some other purposes without consent. You can't do it. You'll have to be fair and transparent you're dealing. I mean, that is also in under section 4. I don't know why it was needed. You can't do anything through which you can circumvent the provisions of this act. This is a bill right now. This has not come. But this is again a result of the fight against big tech. I will go back to now the Meta case. Now look at the Meta case, what happened in the Meta case. So
We can close with that.
yes, sure. So in the Meta case, you'll see the issue was basically the WhatsApp comes with this privacy policy update. And arguably, the position is that the privacy policy update, which they came in 2021, didn't allow users to opt out from their terms of services. You'll have to necessarily take it where they will actually use your data for cross-platform purposes, for advertisement purposes and other purposes. And if you don't,
Can you explain the privacy policy? What was the policy?
the privacy policy was that they came out with a new privacy policy where they said that if you, I mean, basically they said that you, these are the terms of services. One of the terms of services, they are going to use your data, not the message which you do, but just your data, and they will use it for their other meta companies. So for Facebook, for let's say advertising purposes, right? And if you're not, you do not have an opt-out option from that. And if you don't agree to their policy, then your services will be closed. Basically, your account will be deleted, right? Now, when this happened, people went to the CCI, and of course, Meta then gone back to its own policy, and then it removed that element of coercion that your account will be blocked. It actually left it open. All of that happened. Those are factual, positions in the case. But what the CCI found in this case for the first time is that by coercing people to, agree to your terms of service, unless otherwise your account will be deleted, you did two things. One, you acted unfairly because you're dominant, and two, by using their data for other purposes or for cross-platform services purposes, you have also violated their privacy. And they said privacy itself is a parameter in consumer welfare standard. It's a non-price parameter. So price parameters is basically price, right? But non-price parameters could be, let's say, customer satisfaction. It could be quality. So privacy itself is a non-price parameter. And by lowering the standards of privacy, you have actually harmed consumers, right? And on that basis, they found them to be abusing their dominant position. They also found them denial market access and leveraging dominant position in context of not users like us, but rival advertisement service providers, because they were also big in providing advertisement. And on that basis, it's very interesting. Look, their kind of remedies which they have given, and we'll discuss that. They have said 5-year ban on sharing users' WhatsApp data with other meta companies for advertising purposes. In other words, even if a user were to give a consent, they can't do it because they have 5-year ban that you can't use user data.
Why only 5 years?
They have thought about it. We don't know. There is no statement on this that, first of all, why this ban, and two, if this ban has to be for why 5 years. Second is that they will allow consumers to opt out from their privacy policy if they do not want to share their data. That opt-out policy should be there, and they have to bring their data sharing policies much more transparent, because the data sharing policies are not clear. That which data point you are using for what specific purposes, that is not delineated well. So you need to come out with a very transparent data policy. These are the remedies which have been imposed very broadly on Meta right now, which happened very recently last month, and that essentially takes it to the questions, which I will pause and not get into that where are we heading with the antitrust enforcement? What should be the goals of antitrust? What is good for Indian economy and Indian consumers generally? And we'll also talk about, for that matter, Indian democracy and all of that. And to what extent policy making like digital competition bill can be done in the manner they have been done, where there have been, I would say, very dismal stakeholder consultation. But I'll pause here. There may be a lot of questions here, but I'm happy to take questions now.
Okay, great. So can we minimize the slides? Escape. हाँ, हो गया.
Just a last one, you said Microsoft ChatGPT, what do you mean by that?
OpenAI ChatGPT.
Yeah, because Microsoft and OpenAI have an issue.
Yes, yes, yes. OpenAI ChatGPT.
Okay. That's not.
Thank you, Parth, for covering a lot of detail in a complex area for us. Pretty rapid fire, I must say. I think that if what I can take away from this is that the new competition law, like if we can talk about that, is you mentioned that there are these different considerations. One of them is preventing abuse of dominance. The second is preventing anti-competitive conduct. The third is, it seems towards the end, from what the Competition Commission has been doing, consumer welfare. If we can see it from the WhatsApp privacy case, that they are also concerned about consumer welfare. So several questions. You explained the composition of the commission. What was the composition of was there a commission under the Monopolies and Restrictive Trade Practices Act, or what was the enforcement body? That's my first question.
Yeah, go ahead.
Yeah, I'll just say my questions and then you can respond. But also so within the Competition Commission, to me, it seemed from your narrative, I don't know if it's correct, is that a lot of the changes in terms of the Competition Commission's position seems to have been dictated by other countries holding these same companies to account, whether it is the EU or the United States. So India is sort of, piggybacking on developments and cases that are happening in other countries. And I, for one, am aware of the fact that there are several antitrust cases pending against big tech companies in the United States right now, including Facebook and Amazon and a lot of these companies. A lot of them are going to come to resolution in 2025. So I was wondering if you could say a little bit about what's happening there as well and how that influences us in India. And the third question is about what you said, that the first time privacy as a non-price factor has been used in competition analysis. And I connect this again to cases against Facebook in the United States, where about 45 of there are 50 states in the United States, 45 states have brought lawsuits against Facebook for the fact that their algorithms have harmed the mental health of teen and preteen children. So I was wondering how, sort of human rights of people, whether it's privacy or mental health, are sort of coming into this kind of analysis. And I want to give an example from our work. I wrote this book chapter on health rights a decade and a half ago. And the interesting thing was that in the regulation of cancer drugs, one of so the health rights cases, were basically most of the health rights cases that we have seen in India, for example, have been relating to court pronouncements. And it is not surprising in a way that, the Supreme Court has been making various pronouncements on competition law before the laws itself came into force. Because I find that trend in all of our work is that actually a lot of the laws in this country are based on earlier on Supreme Court pronouncements, especially the ones that enhance our rights. They're all coming from the Supreme Court's judgments, and only then Parliament passes a law. And so within that, what we found in the health rights cases was that particularly with respect to provision of cancer treatment, these arguments about health rights were used to prevent the use of patents, to exclude or to put the price of the drug at a high price. So it is interesting to me to see that those human rights considerations are also sort of coming in here. And of course, I want to hear as to how, it seems like there's only one case where that has been done in the case of the Competition Commission, but do you see that also in other cases? So those were the first few questions I had.
Yeah, but on your health right issue, the way you have brought it, can you repeat your question on that? That how
Yeah.
you're bringing the health right issue with this privacy case?
No, not with the privacy case. I was giving an example of the fact that, and basically, a lot of the debate on big tech is related to intellectual property, is related to innovation.
Right.
as the principle that is grounding that, right? So intellectual property protections are under the WTO and the WIPO, there's the patents, and we had that discussion with the provision of drugs during the COVID pandemic as well, because the demand of the developing world was that a lot of these drugs are being priced very high and so on and so forth. So one successful case in India,
Right.
which was brought by the Cancer Patient Society, it was argued by the Lawyers Collective. They actually use the right to health, which has been read into the right to life. So,
Right.
in my book chapter, I study all the right to health cases that had been decided between 1950 and 2010, which is 2011 is when the book came out. So, in one of these cases, the argument was made that the right to health must trump intellectual property.
Mhm.
And therefore, in India, because we are the generic drugs manufacturer, so this case was a patent protection case against these generic drug companies. And the argument was that right to life, right to health is more important than these patent protections. And we saw that same dilemma play out in the COVID vaccine. I'm relating it not to the WhatsApp case necessarily, although I see a connection because privacy is also a fundamental right under the right to life. But in the Facebook cases, for example, that's a direct connection in the sense that they are saying that uh, not necessarily competition law, but they are going against big tech on the ground that Facebook's algorithms harm the mental health of teen and preteen children because they were not supposed to target children, but they did. Right? So basically, I'm seeing this intersection between human rights, health rights, whether it's mental health, physical health, cancer, etc., with economic protections and with areas where we didn't necessarily see those kinds of arguments before, but which need to be there, and we are seeing that in certain areas. So I just wanted to hear your perspective on that.
I felt that your seminar covered 4 different almost topics, which are worthy of a seminar itself. And adding this one, you're already, a lot of things have become conflated. If you're talking about competition, within that, we have 3, I would call epochs of competition, the way you
So do you
described.
have a question?
I have, because I'm saying unpack it, because I'm totally confused and I've spent years on this subject,
Right.
including this particular competition. This whole business about economic power, market power, the first set of things. The most recently on digital competition, if you're going to focus on it, are you going to focus on competition or the interface of competition on the one hand with, like yesterday, there was a webinar, not a webinar, a seminar on business groups in India at CSEP, that on industrial or economic things, which is what your original. Now there's a whole business of whether you call it privacy or human rights. Those are 2 different sets of issues in the legal debates which are going around in the world.
That's so my point is that actually
back it and then
no,
decide.
there are, so yes, I think we will take comments one by one, but I think that it is a it's
I don't know which one. Ask first, because I have a challenge. I have several things which I feel, right from the his basic premise is about when you talk about economic power, what does the Constitution mean by economic power? There's enough work to say it's not market power. Is it, it's basically influence. Is it political power that you're talking about? And because if for just another one, that since you mentioned about property rights, IPRs basically give temporary monopoly rights. And that interfaces in economic terms with what, the ability to influence things. So that I'm just afraid that we are conflating too many things together. So
I don't think we are actually. And in fact, the constitutional directive is pretty clear. The Article 39B, which was on the slides, explains that the state is obligated to ensure that concentration of economic power. So
But
there
what
is
does it mean in
yes,
practice?
but
That's not
but
been
it's very
interpreted.
clear that it's economic power. It's
But
not
what
about
does it
political
mean?
power.
I'm saying, what
So
legally,
you asked your question, let him
okay,
respond.
yes, is it the same as market power? If not, what is it?
So thanks. May I come first to your questions and then I didn't get your name though.
My name is Anupam Khanna.
I'll after I have at least addressed some of these what I feel about. So first of all, on the MRTP commission, as there was a commission at that time, I am not very sure about what the composition was. Was it part bureaucracy or part judicial membership? But yes, you had a body in the MRTP law as well. That's your point number one. The second point which you made about was that that I was trying to allude that some of the developments in India has happened where they piggybacked on what happened outside India, and to me it seems so. And the reason being is that that's not just India's case; it's not India's unique case. It's happening around the globe, right? So back in 2012, Anu Bradford talked about this whole Brussels effect, right? And she talked about Brussels effect from a extraterritorial application of EU laws, and that effect has become very wide now. It's not just extraterritorial application of EU laws. It has become so deep and wide that now people are framing laws mirroring EU law just to sometimes on geopolitical reasons, sometimes to retaliate, sometimes for other things. So, for example, I'll just give you an example. EU has come out with a law called CBAM, right? Carbon Border Adjustment Rate mechanism, on which they will make, a carbon cost merely because your products are more carbon intensive, which is coming in the country. Now, more and more countries are talking about framing a similar law. So, I think the advancements which happened within EU, particularly around the big tech, has surely influenced Indian policy making and regulatory activism both. I think so, and it has happened in other countries as well. Your third question, which is about what's happening in the United States. Yes, so I mean there a lot of criticism against United States, at least from certain sections, that US has been slow in enforcing antitrust law while he was doing it. For example, again, Anu Bradford calls it a very techno-libertarian model, which US followed for longest period. But that is seeing a reversal in the last 4 or 5 years, and more cases are coming against big tech. And you're right, as we speak, there are several cases pending against some of these big names, including Facebook, Google, and other companies. And some have seen some judgments already. There are questions about remedies, and all of that is happening. So that's there. On your last question on this, harm to children, Facebook, all of that, and connecting into health rights, that's a very valid question. And therefore, this is one of the trickiest point when it comes to antitrust law. One is that what all antitrust law in itself can do. I mean, what is that? What all wrongs it can remove? Is antitrust law the sole panacea for every kind of wrong which we're talking about? And if that's one question. And the second is that what kind of remedies we can think of. Herbert Hubenkamp has time and again said that in digital markets, it's very difficult to, first of all, identify, even if you identify the harm, the remedy, right? He has said both things. For example, you take the Meta case here. The idea here is that other smaller players are not able to compete with you because you have become so big. Now, if you look at the remedies which CC has proposed, I don't know how these remedies are going to help the smaller companies to compete with Facebook or Meta for that matter when it comes to advertising. None of them will actually do, to my mind. While yes, it is right that there is evidence and literature around how it has harmed teens, but the question is that what should antitrust law do? That now Australia, as we speak, has perhaps proposed or already thought about something where they are trying to say that, I mean, at below certain age, you can't really access something. Should there be some sort of, consent, parental consent and controls, or should there be a different version of Facebook for children where there is a very different version of algorithm and all of that? I mean, those are open questions. I really don't have a solution to this, but what I do think is that perhaps antitrust law is not suited to actually cure this problem, which we just talked about. On your other question, unless there are follow-ups, I'll take that. On your question about too many things and conflation, I think because this was a talk about legal history of the competition law in India, and naturally it will talk about political economy. So naturally, I had to cover many things. So it might have come across as conflicting because we have tried to touch many topics. So apologies if it came out confusing.
So, Parth, we have a very attentive Zoom audience who have been listening patiently, and they have a few questions. The first is, maybe I can just list them and you can answer them all together. What would be the impact of killer acquisitions with the introduction of DCB? I don't know what they mean by DCB, but you probably know. Another question is, what could be the alternative to the ex ante provision in the DCB if the market has been tipped towards a player And how does a company identified as SSDE impact the Indian economy? So I think these are related questions. And the next question is, what is the jurisprudence behind designation of core digital services and ADs? Why don't you respond to these and then I'll ask the next set.
So, just trying to write down before I forget.
Hmm.
So, the first question on killer acquisition under, I think it's deal value threshold, which we talk about. Just to give a context to everyone. Uh, there were significant sets of amendment to the Competition Act earlier this year. Competition amendment, I mean, came in force earlier this year. It was done in 2023. One of the amendments is about reviewing mergers on the value of the deal. So before this, the merger review in India was based on the financial size of parties. So what is your asset? What is your turnover? If your asset and turnover, and there are like the whole mechanism there, waterfall mechanism, if they cross a particular threshold, then that acquisition or merger or combination, as we call it, becomes reviewable by the CCI. CCI will now look at it. Now, globally, there is a debate that what happens is that if you just look at asset and size, you are looking and missing many what they call killer acquisitions. By that, they mean that there could be an early stage startup who is doing a great or producing a great product or service. They may not have a huge asset and turnover to begin with, and they have high valuation because they have high prospects, and it's a high value deal, and a competitor comes and acquires it, and it can do anything. Perhaps it thinks that the product which they were manufacturing that is going to compete with the existing product of the big guy. They will acquire the company and kill the product completely, right? So there was debate around that you should look at mergers not just from asset to turnover. Therefore, there are certain killer acquisitions which should be looked at, and therefore you look at deal value. What is the value? What is the amount which you are ready to pay to the target to buy him out? That should be looked at. Now, India came out with the deal value threshold mechanism as well, and it's now in force as we speak. And based on that, it will look at now mergers which cross a particular threshold, which is 2,000 crore rupees, and there are certain other things. You'll have to have a substantial business operation in India for the target, and then you'll have to decide. So the question exactly is that, if I have understood the question correctly, that how would they look at killer acquisition? And I think I have a question. I have a similar question in my mind, because look, the Competition Act still will have the same standards, in the sense that Section 20, subclause 4 will still be looked at in terms of what are the factors based on which you will decide that whether this. Previously, we were making this decision that whether this is going to have a appreciable adverse effect on competition or not. So in which cases a CCI will understand and figure out that, oh, this acquisition will be a killer acquisition. I really don't know how they are going to do it. So I'm sure there will be a lot of subjectivity involved here, and it's going to be hugely debated whenever there is a acquisition which is blocked by CCI or modified for some reason, because they think that this acquisition is going to kill competition or is going to hamper competition. But absolutely, there is no straitjacket answer that how differently they will look at it, other than what is given provided in Section 24. I hope that there's a second question about what are the alternatives to ex-ante regime under the DCB. I think that was the question. And I think if somebody has to go in ex-ante regime, if you are going to look at something as ex-ante, at least you should do effect test. Now, your merger control laws are also ex-ante in that sense, right? They do not really look at post facto, but they are looking at ex-ante. But there is some analysis of effects test. So if DCB has to come into some form, my submission is that at least at some level, it should incorporate an effects test within this law, where at least parties should be provided an opportunity to defend why they are doing what they are doing, and if there is a harm to competition. Now, it will completely change the whole narrative, because people who believe in ex-ante regime, they simply think that this is a time-taking process. This is if this is allowed, then what is the difference between the existing competition? And I share that concern, but I am still on the side of a cautious regulation than over-regulation.
and I will propose, I will like to be, I like to see the DCB reformed in a manner where there is some level of effect test introduced in the law. That is the second question. The third was, what is jurisprudence behind core digital services? Well, I don't know if there is a jurisprudence behind core digital services. To an extent, it has been, it's surely impacted by the way DMA defines gatekeepers and the matrix which they have taken into account. So I think certain services, the commission, at least the report, considers as core digital services, which is your online search, web browser, and a lot of other things. There is no jurisprudence, so to say, which has developed. And that's also a question in the stakeholder consultation, that what is the basis to identify these services as core digital services to begin with. So that those are my responses to these set of questions. Yeah.
Great. We have some other questions about concentration of economic power. Both Hazari and Dutt mention that the problem of concentration of economic power is something which cannot be solved by competition policy and that the two are different. At a broad level, then, how do you think that the Competition Act can solve the problem of monopoly or concentration of economic power, given that it is not the mandate of the Competition Act to address Article 39 of the Constitution? And related to that, from an economic perspective, another question: what are some of the metrics that the Competition Commission uses to measure economic and allocative efficiencies?
So on the first question, I think I would side with Hazari and that. In fact, not only Hazari and that, in the Monopolies Inquiries Commission report, the last committee, there was a dissent which also said that, look, if you have a private economy, if you get into privatization of economy, there will be economic centers of power. You can't really avoid that outcome at all. So I do see that antitrust law or competition law itself cannot. And to that extent, I mean, it could be one of the tools to look at if economic concentration of power is something which is an abhorred idea within a, let's say, democracy, or the kind of democracy which we have adopted. Antitrust law alone cannot do that. You have many other tools to do it. Taxation is one tool about that. I mean, wealth transfers can happen in many other ways, and antitrust is not. In fact, I think antitrust law is effective to an extent where it does merger review, where it looks at abuse of dominance on certain degrees. It can surely look at that, but whether antitrust law in itself is sufficient, or whether it should be the only tool to avoid a situation where you have highly concentrated markets or highly concentrated economic centers or people with high, that kind of power, I think antitrust law itself is not sufficient. What is the second question?
What are some of the metrics that the Competition Commission uses to measure economic and allocative efficiency?
Okay, so I am not sure about any particular metric which Competition Commission itself uses. What happens is that when we look at efficiency test, the parties will provide economic reports, right? They will provide highly, sometimes depending upon case, they will provide from a simple economic report to more complex economic reports to demonstrate, even if there is a market concentration based on HHIs and all of that, why there is, let's say, no element or why there will be no price increase, or how a merger, or for that matter a conduct, actually provides benefits to the consumers through lower prices. So they will demonstrate all of that, but I'm not sure that if there are any particular kind of specific tools which CCI applies in each case.
The next question is, what was the remedial device used against unfair practices before the Monopolies and Restrictive Trade Practices Act? In the earlier slide of your presentation, you referred to two High Court judgments from even before India's independence. What was the route through which those cases were brought against unfair practices?
Yeah, so those cases are actually not High Court, those are Privy Council judgments, and they were based mostly on Section 27 of the Contract Act, which said that contracts which are in restraint of trade, they will be void. So that's the source.
What is your opinion on the recovery of penalty draft amendments 2011 with regards to cross-border recovery of penalties?
I'm not sure I get this question. If this is about penalty guidelines, I don't know. Because there is nothing called 2011 draft of.
Maybe the questioner can clarify the question.
Penalty guidelines which have come, and those penalty guidelines talk about that how should penalty calculation be done. How do you determine penalty from relevant turnover to global turnover? What aggravating factors, what mitigating factors commission will take into account to come out at a penalty percentages, because whether it is 10%, whether it is 4%, 2% depends on all. So if the question is about that, I mean, these guidelines have just come and we had a few thoughts on that, but I'm not going into that right now.
Okay. What are the weaknesses of the Competition Commission? That's one question. And are cloud services and cloud computing taken under the same meaning under the DCB?
So, what are the weaknesses of the competition commission? Big question. No body for that matter is perfect. I think the competition commission can do a lot better if they have more, skilled human resource. Because the kind of work which they are doing is interdisciplinary. So it is just not law. It has a lot of economics or economic ideas involved in that. With more of their intense scrutiny towards big tech, I think they need really more skills set of hands to understand the businesses and how it actually works. So my key recommendation on that front would be that perhaps a more skill set of human resource, better trained human resource would be always helpful. On the other question on cloud computing, whether it is included in cloud services or not, I'll have to really look at the digital services provision, whether it is. I don't want to answer the question just on without looking
Sure.
at the definition.
So we have 5 minutes left before we close. Are there any questions in the room? So you can please try to be brief so that he can also respond. Yes.
Thank you. So I'm student of competition in the industry. So my question pertains to evolution of the history of the subject, right? From the inception till today, we see amendment bills and what you call laws and acts and constitution and all. Everything is coming and going. And we are trying to amend them, amend. The main thing I want to bring into your notice, I'm talking only about India, not US and China or Russia, just India. In India, people from bottom to top give a damn to the law, what you want to implement here. Nobody cares about the law, nobody. So this is my concern. When you
Thank you, sir.
and there's bypasses, no matter what law you they bypasses. They're the advocates and they're the lawyers and they're CAs and all that. They tell you if you want to commit a murder, they give you bypass.
Okay, thank you. Thank you for your
So
question.
This is what I want to bring to a point. We cannot implement, and you have said.
Thank you.
Enforcement
I've
of law
got the
is very
question.
poor in this country.
Yeah.
You said, sir. This is what I'm implementing.
Thank you.
I'm just deciding.
Yeah. And then one last question on Zoom, how competition laws have been able to tackle the natural monopoly sectors like electricity distribution? If you have any thoughts on that.
Again, a good question. I think electricity sector is one sector where there is a good amount of concentration. And I mean, this is also a sector which is, even before competition commission, is a highly regulated sector, right? I think the key body, which is the Electricity Regulatory Commission, I think we have a greater role to see there, because it's a highly regulated sector, to see whether there can be more intense competition and pricing in that sector. So that would be my response. Of course, Competition Commission is not debarred from that, but I'm not aware if there have been any good cases of electricity sector which has come before the commission, or the commission can enforce anything on that.
And do you want to respond to lack of enforcement? Do you see lack of enforcement, or do you see enforcement of the laws here?
Oh, no, I didn't mean to make a sweeping remark that there is no enforcement of laws if I came across like that.
I don't think
There
you did, but
were-
you can clarify.
There were, criticisms on MRTP's functioning, which is with all laws. And I didn't mean to say that there is no enforcement of law in this country. And for that matter, I think I would commend CCI that they have done a good job in their first 15 years. They are a very nascent body, just came in. Actually, they came in force only in 2009, because the laws only came into force by 2009. Before that, it was into a different mode altogether. And in last 15-14 years, my sense is that they have done a good job.
Okay. Yeah, Devashi. So we are out of.
And enforcement is there. There are bypasses. You can't check that.
Yeah, Debashish,
Interest because I mean,
use the mic.
if we see the way at some point, so Geo, the OTT platform, like they sort of merged the Hotstar, and like there is a like the OTT space also is getting highly very concentrated. Like if you look at the past 4 to 5 years, so do you think like there is any kind of an active debate on, because a lot of the sports or other sort of entertainment that is at some point it will only be available in very select OTT platform. I mean, if you look at the way the sort of Geo sort of aggressively pushed its this thing in the last few years or this thing. So do you have any kind of an insight, or is there any discussion of
Yeah,
regards
I
to
mean, I
that?
think already discussions are going on OTT as well, right? The OTT is a new media now. First of all, within the OTT market right now, I mean, already there is a lot of competition, right? So you have Netflixes and Primes and Hotstar and or I mean, Geo is also there in different form. So you already have a competition there, Sony Live and whatnot. And to the extent there is concentration, first of all, between, I mean, if there is a concentration on OTT itself, that will be a uh, cause, I mean, I would say that will be a cause of concern. But on your specific question on sports rights, I don't know which event you are alluding to. But look, even in the outside world of OTT, right? When you did not have OTT, the broadcasting rights were always with particular channels, right? You did not have always that you have ESPN and DD Sports, and so ultimately it's a bidding process, right? And in the bidding process, the best bidder wins. So I don't really necessarily would see that merely because one OTT platform has got exclusive broadcasting rights, therefore it's anti-competitive. I think the process has to be looked at. And if the process is a competitive process, I would say it's fine.
So we are at the close of the hour. So I just want to sum up, Parth, and thank you for this really fascinating, expansive talk. As Sir here was saying that, we covered a lot of ground from what is economic power, what is abuse of economic power, to actually talking about anti-competitive practices, abuse of dominance, and consumer welfare as some of the guiding principles of the competition law. I think that one of the things that we have been sort of mapping as part of this series also is that a lot of these changes in thinking, how, first of all, how interconnected we are with the larger discourses. So there, it is no surprise whatsoever that from 1950 to 1970, and at the height of socialism, so I talked about this in my talk, the last talk that I gave in the property rights talk, is that the larger discourse on development was focused. We're talking about breaking down concentration of economic power. At that time, land reform was considered the most important way of breaking down economic power. Today, we are talking a lot about taxation. And you're also saying that antitrust law is not the way to perhaps to go to break down concentration of economic power, but rather some of these other goals that you've talked about, abuse of dominance and so on. And so we see these shifts in discourses. So the Monopolies and Restrictive Trade Practices Act comes at the height of socialism, right, 1970. And it is no surprise that neoliberalism, and I don't think that it was the fall of the Berlin Wall that led to sort of this, the liberalization in India was essentially happening because it was being pushed by the World Bank and the IMF. And we have been in this neoliberal moment since then. And we see the liberalization of various sectors of the economy. And that's why we have something called the Competition Act and not a Monopolies and Restrictive Practices Act. So I think those are the larger global developments. And I think that you've given us a very good sort of overview of all of that history. So thank you so much, because you packed a lot in the space of this lecture, right? But I think that for the future, we are going to explore some of these themes further in subsequent talks, because I think it is very important for us to understand that, the various sites of power, and to also understand, because there is, this very idea, apart from the fact that legal history is something we use in the Land Rights Initiative work to illuminate problems of the present by looking at the past, but also my work in particular and what I've tried to build with the Land Rights Initiative is this idea that efficiency is something that cannot be achieved without equity. So, and we have this conversation about efficiency, about allocative efficiency, about efficiency in other contexts. But the fact of the matter is that there are no sort of perfect markets anywhere. They never have been. There's never been a clean slate anywhere, even though. So we are starting with, like you said, we already had significant concentration of economic power before the MRTP Act. Now we have a different concentration of economic power. Now we are more interconnected with the world also, post neoliberalism, post the liberalization of economic policy. So all of these things are to be seen in that context. And therefore, for those of us who are interested in questions of rights, whether it is land rights, health rights, water rights, we have to sort of look into these aspects of the law as well, because it's the site of power is no longer with the government. And I think your point about, and the discussion we had about the composition of the commission is very important, because obviously you cannot expect retired bureaucrats to understand detailed economic principles, nor do you expect them necessarily to understand human rights. So the fact that they now have a lawyer on the commission, but who is that lawyer? So those are the questions that we need to think about. And the final thing is, how binding are the competition commission's orders? And are those then appealed to the courts? How are courts responding to that? Are they interfering? Are they not interfering? Perhaps you could respond to that.
Yeah, so I want to respond. So yes, the orders of CCI are appealable to NCLAT. Of course, you have the 226 route for what is not appealable. And yes, it is true that like all other sectors, these appeals in most cases go up to Supreme Court. So in that sense, the final outcome of CCI decision does seize a long time by
Yeah.
the time it is finalized, right?
Right.
So that has also happened in terms of recovery of penalties. In most cases, penalties have been, let's say, 10% deposit or 25% deposit, whatever somebody would have, which court would have given what, and and thereafter it is pending. So yeah, there is a long journey, of course. I mean, from the CCI order to final decision from the Supreme Court, in some cases, people can easily calculate sometimes, let's say, 10 years.
So that also sort of corresponds with our finding. Of course, land matters are the most, the maximum number of disputes in the courts are land cases, and the maximum pendency is also of land cases. But even for something like competition cases, we are seeing that there are like
Yeah,
at least
long
10
time.
years of this thing. So the questions of judicial pendency and things like that we have also been talking about, how to redress that and the finality of the order. I think there are many, many intersections and parallels with what we are doing. And for our wonderful audience who have joined us for this talk and stayed throughout the series, we will be having hopefully a discussion on NCLAT and bankruptcy law in the new year, and a few other financial laws now that we have started these discussions to sort of take that.
Yeah, I just wanted to make one point because I was thinking about this other kinds of harm which you're saying. And I also feel that somewhere, the governments are not also looking at other institutions within government and their functioning and their enforcement capacity and mechanisms.
Right.
And therefore there is a scapegoating of big tech in the sense that, if you have a hate speech or a completely illegal speech on Twitter, understand that Twitter or X is liable, intermediary liability rules you have already enforced. But what happens post that? Like if somebody cautions you or if somebody flags you that there is this speech, where is the law enforcement? If somebody is making a completely, let's say, misleading information as being a public officer, what
Right.
is Election Commission doing? I mean, it is being brought to us, but you are saying, oh, Twitter is doing this,
Yeah.
Facebook is doing this, but the other core enforcement authorities of traditional, why is there no public infrastructure investment there to make them more robust, make them more accountable, make them more equipped to deal with the challenges of big tech? That discussion is not happening, and there's entirely a discussion has been shifted towards that. Well, they're meddling into free speech, they're meddling into political speech, they are driving a narrative. True, I'm not denying that. Well, there are instances these have happened, but equally, I mean, there are
Instances.
machinery, the government machinery, traditional machinery, which is supposed to do its job, they are not doing their job.
Right. So, I mean, the way I see it, and I think if we can I'm just going to close with this idea that in my understanding, human rights are really about rights against concentration or an abuse of power. Now, that power can reside with the government, power can reside with corporations, big tech, and so on. So I think for those of us who are concerned about, human rights, the goal should be to sort of ensure that there is a regulation of power. As citizens, we have been given some rights under the Constitution. There is a right to freedom of trade, but there's also a right to free speech. And just as you were explaining that, there is a conflict sometimes, but there is a way of harmonizing these rights. Sometimes, in fact, in many instances, rights do conflict with each other. But I think that in all of these instances, whether it is the Aadhaar judgment of the Supreme Court, the court has spoken about the dignity of the individual as being intrinsic to the right to life. The right to life is the most important right. And all these rights have to be seen in that context. So I think absolutely there has to be a building of state capacity for the commissions that are trying to protect rights, both within the government and those that are trying to regulate corporations. And, look forward to seeing how the law continues, how the law and the commission continue to unfold. But I think it would be very nice, Parth, as we've discussed, if, we could write something about the commissions themselves. In fact, I think for any of the researchers here, perhaps a paper just on the commissions of India and how to better capacitate them. We worked closely at Land Rights Initiative. We worked closely with the National Commission on Scheduled Tribes. They adopted our research as part of their annual report to the president. And it was a very clear example that if the commission wanted to do something, then they didn't have the capacity. We provided them the intellectual know-how, but because there was some will to do it, it happened. And when there isn't will to do it, we found that the commission has been pretty much defanged now. So these are some of the things that we all need to think about. That as citizens, our rights are not just going to be, and I say this to the lawyers also, like, most people, most legal academics tend to write about constitutional law, but actually constitutional law is present in all laws. And we just don't see enough being written about the values of the Constitution, our values as citizens, are not being seen in these other sectors, which is why we lament that our rights are not being, protected. But we have not done enough to study how our rights sort of permeate the legal structure. And that is why legal history. And so that brings me to the close of this. Thank you once again, Parth, for taking our time.
Thank you so much for giving me this opportunity.
And thank you to our audience for joining us. And see you all in the new year for the next talk in the series.
I also wanted to thank my colleague Pawan and Bhavi who have worked with me on this slide. It has been a great work which they have pulled off. Thank you.